Good morning. Welcome to the Bell and Pollock Legal Show. I'm Gary Bell along with Brad Pollock. Every week we bring this show to you to educate you and teach you about injury subjects. We're injury attorneys. We're glad to do it. If you missed part of the show, if you want to listen to the entire show again, all you have to do is go to our website, which is championsofthepeople.com. Website's championsofthepeople.com, and click on Bell and Pollock on the radio. It's on the homepage on the left-hand side, and away you go to all of our podcasts. They're free. You can play them. You can download them, and we're glad to do it. We've covered a lot of injury subjects over the past few years, and we're going to continue to do it to educate you, to help you. You know, sometimes people call us and ask us to cover a specific subject, and we do that. And if you want us to do that, you can call us or email us. Just go to championsofthepeople.com and email us, and we'll be glad to consider your subject. Also, we have a live call-in show on Saturday morning, 7 o'clock in the morning. And that show is you can call in live on any legal subject, and we'll solve your problem on any legal subject. We're glad to do it. We provide it as a community service, and so we've been doing that for years as well. Okay, today we're talking about multi-car accidents. You got to take you through this because it's very, very important. And a lot of people try to get advantage. A lot of insurance companies try to take advantage or get an advantage right at the very, very beginning. So we're going to talk about liability, meaning who's responsible, who's at fault, because that's the first thing that needs to be determined when you have a multi-car accident. You know, our typical example is you're injured in a car crash, and then what are your rights and remedies from there? In a multi-car crash, Brad, you got to prove liability. Sometimes there's a pro rata liability. Two people are at fault. Sometimes one person's at fault. But the critical thing is to prove who's at fault and get going with regard to your injury claim.
It certainly is. You have to determine, and you know, at times both parties will be at fault for different parts of the accident, or for the accident occurring at one time, or for failing to act reasonable under the circumstances of approaching or being near the first accident. So you always have to be able to look at what the people have done, how they did it, what their involvement was in the accident, and try and start apportioning your damages or your percentage of fault to begin with. Don't worry about your damages right away. So try and get your percentage of fault.
Right. You know, sometimes we need to hire engineers to do this because you have to have precise engineering calculations. Sometimes we don't need engineers, and so that's one reason you need an experienced attorney working on these type of cases. But let's talk about, you know, a pretty easy one to prove is for a car, and it happens more often than you think. A car comes across the center line, usually drunk, usually on drugs, center line on major highways, and hits car number one, then hits car number two. Well, it's pretty clear that the car that's at fault is the one that crossed the center line and caused that accident. However, it becomes more complicated when you have T-bone accidents, multi-crash pileups on the highway, or even a rear-end accident where there's 3 or 4 cars at a stoplight.
Sure. Those are problematic in the very beginning as to whether you should say the one person who caused the series of events to start should be 100% liable because but for that particular action, nobody else would have been involved in the accident, or whether you have to start apportioning fault among other people because they should have taken some kind of action in light of what was occurring in front of them or around them.
Right. And later on in the show, we're going to get into the doctrine of comparative negligence, which is a statute in Colorado, and it is very important, and it's critical in most cases, including these type cases, comparative negligence, because the insurance company, as we've told you, is going to try to seek out a way, find a way to blame you for all or part of the accident. And so you need to separate that out. And if you have difficulty doing it, you need to get an attorney. You can call us at any time at 303-795-5900. That's 795-5900. But Brad, let's talk a second about the rear end accidents. You've got the typical rear end accident. Somebody stopped at a stoplight, then somebody runs into them, and that's pretty clear liability. Although we've seen the insurance company try to blame the driver and that got rear-ended.
Right.
Anyway, but let's talk about a 3-car accident at a stoplight, and the furthest car back hits the middle car then hits the front car. And then that can become complicated from there.
Well, I can almost promise you that when you start getting involved in multiple car accidents, you better get an attorney. You're going to have to get somebody involved to help you. But here's the thing. Look, I think in your scenario, you said if a car hits a vehicle, and that vehicle then is thrust into the other vehicle.
Right, so the car in the rear hits the middle car hits the one in the front. Everybody was stopped. So, how do we decipher that?
Everybody's going to stop and look and say, well, that's the end car's problem. The car that started and initiated the contact, but for that car hitting the car in front of them, they wouldn't have gone into the car in front of them. And, so if you do an A, B, C, and C is the car that smashed into B first, and B then gets propelled into A, C is going to be responsible for everything. Now, you've always got to watch out, because one of the first things that the insurance adjusters for C is going to try and determine is whether or not B was properly at the location that it should have been at. As in, did B was B too close to car A in front of him? Did B have his foot on the brake, or should B have had their foot on the brake? Was the light just turning green, and therefore B was starting to inch forward anyway? So they're still going to try and find a way to avoid responsibility for what they did. Right,
and along that line, sometimes your cars are at a stop, then the light turns green, everybody starts to move, but then for some reason the very front car has to stop. Maybe traffic stopped. Maybe something happened on the roadway. They have to stop, and then there's the rear end accident.
Or simply it's taking too long to go, according, from what other cars feel they should be doing.
Yeah, people become impatient. But the one I really want to point out today, and there's different permutations, obviously, as you can see, of this entire situation. But the one I want to point out today is you got car number one in front. Then car number two is the middle car. Then car number three is the one in the back. Okay? Sometimes, or many times, the insurance companies and the drivers try to say that the middle car first rear-ended and struck the car number one in front, and then car number three came along and hit both of them, and then propelled the middle car into the front car again. And sometimes, so now, how many accidents do you have? Maybe two, maybe three, maybe four.
That goes back to the situation that we've talked before. You can get it off our webcast. Of the problem you face when you're being interviewed. And we've talked to you many times about the fact you've got to be careful when you have the interview, because when the insurance adjusters talk to you, they're going to start asking you, did you feel two bumps or did you feel one bump? Or how many bumps did you feel? Did you feel your bump before you heard the other accident? And what they're trying to do, once again, a car three who initiated the contact, that adjuster is going to try very hard to try to argue some other reason for car number one having been hit, other than three having run into two and two running into one.
Right. So the middle car sometimes is really questioned. And that's why we've covered before in our previous podcasts that you must have a clear head. You must give this statement when you're thinking clearly, and you can accurately remember the events. You don't want to guess, because when you guess, you get into trouble. And when you're guessing, you shouldn't guess anyway. You need to accurately remember the details of the accident. Sometimes it happens so fast that it's very, very complicated. But look at this. If you're the middle car, somebody's going to try to blame you. If you're the middle car and three of them are lined up, and they want to know if you hit the car in front of you before the car behind you hit you. And maybe you're still connected with the car in front, so there's one more impact. Maybe you hit the car in front of you. The car in front of you went a few feet, then you got hit again, and then you hit the car in front of you again. In that situation, there's three different accidents, but you must be accurate, and they're going to look for this, even if it didn't happen.
And when the questioning starts, you better be careful as far as what you say, because they're going to try and read into it what they want to have read into it. Sometimes they're going to ask the car in the very front car, well, did you feel an impact and then hear an accident behind you? As in, well, were you hit first and then hear another accident? And so now they want to blame, that's a way to blame the number two car on everything.
Right, and skid marks are important, horns are important, witnesses are important, car damage and the type of car damage is important, how the damage occurred. Sometimes engineers can back it up through the laws of physics and property damage to prove exactly what happened. And therefore, these multi-car accidents, which should be simple, that's what we're covering today, are not simple. And many times you need an attorney. And you can call us at any time. Our law firm is Bell & Pollock. Our telephone number is 303-795-5900. That's 303-795-5900. Or just go to our website, championsofthepeople.com. And you can contact us. You can email us. We respond to people and questions every day. Come in to see us. We'll give you a free initial consultation, a free legal game plan. And when you leave this free initial consultation and game plan, you'll understand your rights. You'll understand what you need to do. And you'll understand what you specifically need to do in the next week, next month, and the next few months. So 303-795-5900. Today we're talking about multi-car accidents. We are Colorado's premier injury law firm, and we are your champions of the people.
Ready for an extraordinary lunch? As fast or as slow as you want it? With all fresh ingredients? Caitlin's Restaurant has it all. Express lunches that won't keep you waiting. Or, if you prefer, lunch served in that old-fashioned homemade style. All made fresh on the spot. Whether it's a fresh-made sandwich with homemade chips, quesadilla loaded with cheddar or jack cheeses, or scratch-made soups, you'll find everything you love at Caitlin's. Caitlin's is located on Mississippi just east of Colorado Boulevard next to Bookies. How about green chili chicken stew? Think about a variety of fresh-made sandwiches or 11 different kinds of burgers made to order with 1/2 pound of the finest USDA choice lean ground beef. You might favor a homemade New Mexican recipe with carne adobada burritos, chicken enchiladas, carnitas burritos, served with hash brown special recipe beans, cheeses with guacamole, and your choice of homemade red or green chili sauces. For those who prefer the lighter side, there are fresh made salads and lighter fares, sure to delight. Try Caitlin's for lunch or breakfast on Mississippi, just east of Colorado Boulevard next to Bookies. Call 303-798-6600. You'll love it every bite of the way.
Let's talk about insurance companies that don't pay benefits. Monies that should be paid to you, the insured, like payment for medical treatment, for medical bills. As my military commander used to say, listen up. If you have a med pay policy with your car insurance company and they refuse to pay your medical bills from a car crash, you may be entitled to compensation. If you've been injured in a car crash by a driver who had no insurance and your own car insurance company won't pay you, you may be entitled to compensation. Your own car insurance company owes special duties to you. They cannot just arbitrarily refuse to pay your insurance benefits. I'm Gary Bell of the law firm of Bell & Pollock. Bell & Pollock has years of experience in dealing with insurance companies that improperly refuse to pay. Bell & Pollock are the champions of the people. You can find us at bellpollock.com or championsofthepeople.com. You can also find Bell & Pollock at Facebook, or you can call us at 303-795-5900. That's 795-5900. One call, that's all. Good morning. Welcome back to the Bell & Pollock Legal Show. Gary Bell, Brad Pollock. Our law firm is Bell & Pollock. We're conveniently located in Greenwood Village, I-25 in Orchard. You can come see us for a free initial consultation. Today, we're talking about multi-car accidents, and you first must jump on liability, meaning you must first be able to prove who's at fault, because if you can't prove who's at fault, brother, the insurance companies are never going to get to the damages, never going to get to payment, and they're never going to pay for your car. They're never going to pay for your injuries.
That's right. And insurance companies, in a way, relish the multi-car accident to the extent that it gives them somebody else to point at. And they like that. They can defer some of the liability. They can defer some of the responsibility. So what they're doing is they're saying, gee, I think I'll go ahead and push some of this liability and some of this responsibility onto another car that the plaintiff is saying caused part of the accident. The injured party is saying they caused part of it. And so the chances of getting the two insurance companies involved in the accident to agree and come to a total percentage of 100% responsibility is next to impossible. They can very well look at the plaintiff or the injured party, and they'll look at the injured party and say, well, we agree you didn't do anything wrong, but I think car number 2 is 80% responsible, and car number 2 says, oh, I'm only 40% responsible. And now the fight gets because you can't get the two adjusters to agree as far as who's got a total responsibility, so that it adds up to 100%.
Right, and it's very critical that you get this on this right at the beginning, because the words liability, those are lawyer words, legal words, liability, who's liable, who's at fault, who's responsible is what it means, and you've got to be able to prove it. You're not going to get your car fixed, you're not going to get paid for your injuries or damages if you can't prove who's responsible. The next thing these insurance companies try to do is they try to blame another driver. So there was 3 cars involved in the accident. They try to blame, car number 2 and car number 3, the middle car and the very back car on a rear end type accident, as we've been covering. But also they try to blame you. And then so add into the fact that they're blaming other drivers, and then they're trying to blame comparative negligence against you, meaning you were negligent, meaning your percentage of fault affects your recovery and can sometimes destroy your recovery. And so that's superimposed on top of other drivers that were at fault. It becomes very complicated.
It becomes complicated. It's one where you're going to find yourself in a maze of trying to explain or trying to understand how these people can't just be honest and say that and admit to their own responsibility, but they always want to look at somebody else. On a multi-car accident, you've got to remember you could have, and something that's important is you've got to try to find out what all the different people are saying as far as who's got what responsibility. You can't it's not just what the other guy said now, it's what the other guys said.
Plural, yeah.
And there can be a problem where it ends up being 2 against 1 on what's being said.
Well, not only that, then they try to take your percentage of negligence. So let's say they're trying to say you're 40% negligent, 45% negligent, and then compare it to the drivers that really caused the accident. And so that reduces your damages. That reduces and eliminates the amount of money they're going to pay you.
Well, yeah, you get this. Car number 2, who caused part of the accident, and car number 3, who caused another part of it. First, they'll say, well, your neck injury wasn't my responsibility at all. I don't have any part of the neck injury. And your back injury, I only am responsible for maybe 20%. Car number 3 says, well, I think car number 2 caused all the neck injury, so we're not going to take any responsibility for that. And we disagree with the 20%. We think car number 2 actually caused 60% of the back injury. So now you've not only got them fighting over what portion or what percentage each one caused to the back, but they're also arguing over who even caused any injury to the neck.
Right. And so the percentages of fault can apply to the who was responsible or at fault for the accident, and the percentages can apply to the injuries and damages. And then it becomes more complicated. So that's why we say, sometimes we tell people you don't need an attorney, but in this area you do need an attorney, and I think you can see why. Because we're just touching the surface of the situation.
Sure, because what happens when car number 3 has a $250,000 insurance policy and car number 1 is uninsured or has a very small policy? I'm sorry, car number 2 is uninsured and has a very small policy, and car number 1 is you, and you're looking and saying, okay, now I've got the person with $250,000 coverage saying, I don't have any responsibility. I got the person with no insurance, not really calling back except having left a statement saying I didn't do anything or cause any of that injury, or that only has a $25,000 policy saying I didn't cause much injury at all. And then you have to start putting your underinsured motorist carrier on notice because you might not have enough coverage, even though there may be a huge amount of coverage from one of the other.
Right. And as I said, we're just touching the tip of the iceberg. This becomes very complicated, but you need to know about these things. We're trying to break them down into the simple components. You need to know, for example, in that last example, there's one car at fault had no insurance. One car at fault had $250,000 of insurance. So the $250,000 insurance company is going to say, we're not at fault at all, 0%. We don't want to pay. We're not going to pay. And the person who is at fault is the one who has no insurance. So then it all comes back to you. You need to understand that. You need to get it analyzed. You know what? You can call us at any time. Our law firm is Bell and Pollock. Our telephone number is 303-795-5900. That's 303-795-5900. We're glad to do this. Or you can contact us through our website, championsofthepeople.com. Okay, let's take this a step further, Brad. Sometimes, let's take a different example now. Let's just take a 2-car accident. But in the at-fault driver has no insurance. Okay? And let's say you're a passenger in the car that was not at fault. Okay. You're a passenger. So now you're going to make a UIM claim, an uninsured motorist claim against your own car insurance company, even though you were a passenger.
That's right.
Even though you're a passenger, and you're going to make another claim, UM claim against the UM company, car insurance company of the driver in the car you was driving your car. Okay. Right? Okay. Right. So then now they're going to blame the other driver, and they're going to try to portion your damages between the two insurance companies.
Right. And now you've got a new fight with people that some of whom you believe should be on your side and some who are not. And so now you're arguing with, you now got at least 4 adjusters. Even the hope of being able to talk to all of them in one day is next to impossible. The hope of being able to get them all on the same page is not going to happen. Really, it's not going to happen. Trying to get a conference among all of them is going to be very, very difficult. You can try and schedule it. Trying to get them to all start talking about how much each one will pay. And the problem you've got is if one of them goes and pays and you make a deal with one of them, everybody then is going to say, well, you settled too cheap, and that one had 100% responsibility.
Right. The one that you settled with is no longer involved in the case. They're responsible for everything. I'm sorry that you settled. You shouldn't have settled. I'm sorry you signed the papers. Your case is over with. That's why you need an attorney.
And we call that pointing to the empty chair.
Right.
There's the chair there that now has been vacated because you took some money from them, and now they're empty.
Right. It's very problematic. It can create huge issues. But just know there's a way to do this. And now, I want to make this point right now, Brad, because we hear this a lot in previous years and even now. So the adjusters won't agree on the percentage of liability. They keep blaming somebody else. They keep blaming you. They keep saying you were comparatively negligent. You caused your own injuries. You caused part of the accident. Driver number 1 caused part of it. Driver number 2 caused part of it. You can never get it resolved. So what do you have to do in the end? You have to file a lawsuit because that's the only way it's going to come to fruition. Then they say, the greedy lawyers and the greedy plaintiffs and the greedy injured victim filed lawsuits, and all these lawsuits are frivolous, when in truth, in fact, they won't pay. They won't agree to the prorated. They won't agree to the liability or the percentages, and you have to file the lawsuit to get it resolved.
Well, we have a simple rule in this country. When you can't agree on something, you have a dispute, the way you resolve a dispute is you go to a judge. Now, that can be a mediator, that can be a judge, that can be an arbitrator, it can be different ways, but the bottom line is that's the only way you can resolve the dispute. When you start getting 3 or 4 different people involved, that's a problem. Let me give you an example. Even in a multi-car accident, the question will come up many times as to whether or not you have one multi-car accident or whether or not you have 2 or more separate accidents that happen in proximity to each other. And you start going, well, wow, that really confuses the heck out of it. It certainly does. But, okay, you get people who get in an accident, they pull off to the side, and they get hit by another car. Is that a multi-car accident, or is that 2 separate accidents? You got to try and figure it out. How much time has to elapse? How far down from the road do you have to be before it becomes a second accident? You get somebody who's T-boned and gets knocked down the road a ways or into the other lane, and then somebody comes and hits them. Is that a multi-car accident, or is that 2 separate accidents? And believe me, the way that's addressed or phrased as being either one separate accident or a multi-car single accident is going to affect what coverage there is, who might be responsible, who's responsible for what injuries, and exactly how and who should be paying for your care that you're now going to need for the rest of your life.
And I'm telling you what, you raise a great point, because look at this situation. If, in fact, it's 2 accidents, then the liability coverage applies twice. So if somebody had $100,000 of liability and they caused 2 accidents, it's going to apply twice. Not just once, but twice. And so they want it to be one accident, these insurance companies, because they don't want to talk about separate accidents. They don't want to talk about separate liability. They don't want to talk about, well, another $100,000 argument we have to get into, another $100,000 accident. And these accidents might have happened within a few seconds of each other.
Sure. And your uninsured motorist coverage applies twice if it's 2 separate accidents. If it's 1 accident, it only applies once. So if you're lucky enough, I guess call it lucky enough, to get hit by 2 uninsured motorists, guess what? If it's 2 separate accidents, you've just doubled the uninsured motorist coverage you're carrying. If it's 1 accident, one amount of coverage. Yeah, one limit applies. And so you can call us at any time. Our law firm is Bell and Pollock. I'm Gary Bell, along with Brad Pollock. Our telephone number is 303-795-5900. That's 795-5900. We are Colorado's premier injury law firm, and we are your champions of the people.
Ready for an extraordinary lunch? As fast or as slow as you want it? With all fresh ingredients? Caitlin's Restaurant has it all. Express lunches that won't keep you waiting. Or if you prefer, lunch served in that old-fashioned homemade style. All made fresh on the spot. Whether it's a fresh-made sandwich with homemade chips, quesadilla loaded with cheddar or jack cheeses, or scratch-made soups, you'll find everything you love at Caitlin's. Caitlin's is located on Mississippi just east of Colorado Boulevard next to Bookies. How about green chili chicken stew? Think about a variety of fresh-made sandwiches or 11 different kinds of burgers made to order with 1/2 pound of the finest USDA choice lean ground beef. You might favor a homemade New Mexican recipe with carne adobada burritos, chicken enchiladas, carnitas burritos, served with hash brown special recipe beans, cheeses with guacamole, and your choice of homemade red or green chili sauces. For those who prefer the lighter side, there are fresh-made salads and lighter fares, sure to delight. Try Caitlin's for lunch or breakfast on Mississippi, just east of Colorado Boulevard next to Bookies. Call 303-798-6600. You'll love it every bite of the way.
Let's talk about insurance companies that don't pay benefits. Monies that should be paid to you, the insured, like payment for medical treatment, for medical bills. As my military commander used to say, listen up. If you have a med pay policy with your car insurance company and they refuse to pay your medical bills from a car crash, you may be entitled to compensation. If you've been injured in a car crash by a driver who had no insurance and your own car insurance company won't pay you, you may be entitled to compensation. Your own car insurance company owes special duties to you. They cannot just arbitrarily refuse to pay your insurance benefits. I'm Gary Bell of the law firm of Bell & Pollock. Bell & Pollock has years of experience in dealing with insurance companies that improperly refuse to pay. Bell & Pollock are the champions of the people. You can find us at bellpollock.com or championsofthepeople.com. You can also find Bell & Pollock at Facebook, or you can call us at 303-795-5900. That's 795-5900. One call, that's all. Good morning. Welcome back to the Bell & Pollock Legal Show. We are injury attorneys, and today we're talking about injuries involved in multi-car accidents. You need to know your rights. You need to know what to do. You can call us at any time, 303-795-5900. That's 795-5900. Okay, Brad, let's talk about the situation where you got multi-car accidents. You got 3 or 4 or 5 adjusters. None of them want to accept full responsibility. Some of them don't want to accept any responsibility, and they want to settle. One wants to settle with you. You're the injured victim. And if you settle with them and you don't settle for enough, then the rest of the adjusters, the rest of the people in the insurance company are going to blame the 100% now suddenly on the one you settled with.
Sure. They now know exactly how they want to deal with the case, because the way they want to deal with the case now is to blame the empty chair. And that there's a number of reasons for that. Number one, the more money they can put on the empty chair, say, okay, 80% of your $500,000 of damages is on the empty chair. That's $400,000. We're sorry that you settled with them for $100,000. $100,000 sounded like a lot of money, but guess what? You're not going to get a bunch of your damages.
And guess what? You settled early, which you shouldn't have done. We've got podcasts on that. You took the money, you signed the papers. It's over with as to that one person. That's why they're called an empty chair, because they're not around anymore. Therefore, everybody blames them, the empty chair, and they say there's no more money for you because the empty chair person was 100% responsible, they say.
And at the same time, they've now left you in a position where you have to prove the case. You have to start proving what the situation is. You have to prove they're not responsible. Now you've got the case, and you become the lawyer for the empty chair.
Right. So, and you need to listen to our podcast on quick settlements, early settlements, lowball settlements. You just need to listen to it.
Let's just talk about if there's a multi-car accident, call a lawyer. Call us.
Right. 303-795-5900. That's Bell & Pollock, 303-795-5900, or go to our website, championsofthepeople.com. Today we're talking about multi-car accidents. We're glad to do it. We do this show every week. We are Colorado's premier injury law firm, and we are your champions of the people.